Willie Cobb, 09718. This was,
Michael, what happened with your Cobb? Is our motion to suppress the...
Y'all have a seat if you're ready to get started.
You got it.
You're Willie Cobb, sir?
Yes, sir.
You just have a seat, sir. Ms. Day is here for the state. Mr. Oley and Mr. Cobb are present. Okay. I understand this is a warranted search. Mr. Oley, do you wish to make any opening statement before we begin?
Judge, I'll just be brief. As far as the opening ranks here, you mind?
Wherever you're more comfortable. Okay.
Judge, I just want to really delineate the issues. I guess at this point I'd like to invoke the rule as well.
Any person who may be called as a witness in this case, a rule of procedure has been invoked called the rule of sequestration. What that requires is, in just a minute, I'll have you all wait out in the hallway until it's your turn to come in and testify. It requires you now to speak to each other about what your testimony has been or will be, or allow anyone to discuss in your presence. You may talk to each other about anything else you wish, but please don't discuss your testimony with anyone or allow anyone to discuss in your presence. You may talk to the lawyers if you wish. Okay, so if I can have you all just wait in the hall, bear with us, we'll have you back in shortly.
Judge, since it is my burden, I would like to present the facts. As stated in the search warrant on March 6th of 2009, the Port St. Lucie Police Department executed a search warrant on the defendant's home, which is located at 713 Southwest Avon Street. That's in Port St. Lucie, Florida. The facts surrounding the basis for that search warrant are as follows, Judge. On February 18th, 2009, your client met with a confidential informant. The CI's personal information is known to your client, including his name or her name, address, phone number, and vehicle information. CI's information is not revealed for safety at this time for safety. The CI told your client about the residence of Port St. Lucie where there are currently narcotics being stored. The CI was specific to state that there was approximately 50 to 60 pounds of cannabis in the residence. The CI stated there are also oxys and roxys in the residence. The CI stated there's also a scale of narcotics. The CI told me that the residence gets weekly deliveries of cannabis of between 40 to 60 pounds, with the last delivery being 48 pounds on Monday, February 16, 2008. The CI told your client the resident is known as his or her as Cobb. Cobb was described to your client as a tall, light black male with short hair. The CI stated there are usually 3 vehicles at the home. The vehicles were described as a maroon Jeep, a gold Lincoln, and a gold SUV. The CI stated that Cobb has a gun and has seen him with it in the residence. The CI stated that Cobb has a wife and there are usually 2 children in the home. Your client drove with the CI so the house could be identified. The CI pointed to 713 Southwest Avon Street, Port St. Lucie. Your client conducted surveillance at 713 Southwest Avon Street. I observed a 4-door Lincoln in the driveway. Later in the surveillance, your client observed a maroon Jeep in the driveway. Standing next to the Jeep was a tall, approximately 6-foot black male with light skin. Detectives conducted computer records of the residence located at 713 Southwest Avon Street, Port St. Lucie. The residents were identified as Willie Edward Cobb and Debbie Cobb. Willie Cobb's criminal history includes, but is not limited to, robbery with a gun, deadly weapon, burglary, dwelling of unoccupied, traffic and stolen property, grand theft, cocaine possession, cocaine sale or purchase, and escape. On February 18, 2009, at approximately 2,000 hours, your client met with this same confidential informant from abroad, currently under my control at an undisclosed location. The CI in the vehicle and the CI was driving their search for contraband with negative results. The detectives were positioned in the area of 713 Southwest Avon Street. Your client followed the CI to 713 Southwest Avon Street. Detectives watched the CI enter the garage of the home. The CI met with Cobb. The CI later told your client that Cobb was in the process of bagging up cannabis when the CI entered the residence. Cobb gave the CI a Ziploc baggie of cannabis and the CI left the residence. The CI was followed to an undisclosed meeting place where the bag of cannabis was recovered. The cannabis field tested positive and weighed 53 grams. The CI and the vehicle were searched again with negative results. And Judge, that is, we'd like to actually take judicial notice. That is the application for the search warrant as issued by the client, Gary Grenier, with the Port St. Lucie Police Department. And Judge, I'll just point out...
Mr. I assume you all have the objection to me taking judicial notice of the affidavit and the warrant and the documents in the court file?
Yes, sir.
Okay, I'll take judicial notice of all that is in the court file.
And Judge, I'll just be brief on the grounds for opening. Is that we're really assessing 2 independent items. Is that the lack of confidential informant reliability here is really clearly addressed. I was able to take the deposition of Detective Grenier, who delineated that this confidential informant had never been utilized before and never been utilized again. His affidavit, as I read earlier, does not make any indication as whether he had been utilized before or whether his indicia of reliability is calling into question his truthfulness or veracity. I allege that the statements provided by him or the confidential informant are not reliable, and the basis for that is that since he was never utilized before, there's no indicia that anything that he has stated is nothing more than mere hearsay or conjecture. Now, there is an exception, Judge, to the lack of indicia of reliability. That's the confidential informant or the confidential by exception. And Judge, we're here to show that that exception does not apply to this case. And the basis or the reason why it doesn't apply is that when the confidential informant, this is I think the crux of the whole case, Judge, is that when the confidential informant walks out of the residence and he says, "I received this from Cobb," well, that's all hearsay. And there's nothing to substantiate on the record, whether than audio or video, that a controlled buy took place. In fact, Detective Bernier will tell you it was a delivery. The only issue we've got, truly, is if there was a delivery, there was nothing on audio or video to corroborate that it was, in fact, a delivery. Mr. Cobb doesn't make any statements that come back later or, please provide me money by Friday. All we clearly know is that a confidential informant was given a listening device, and he was also given an audio recording device, and that nothing is on those tapes. There's nothing on the audio or nothing on the video. Also important to note, there's no controlled phone call from CI or the Port St. Lucie Police Department to Mr. Cobb prior to this controlled delivery, which I think is also an important element, Judge. So absent any audio or video corroboration, and we also don't have the officer witnessing Mr. Cobb give anything to the confidential informant, we're relying merely on hearsay, and I think the judge was presented, I believe the Judge Lucie was presented with nothing but merely hearsay to rely upon at the time. And Judge, I'll save the case law argument until after.
Okay, thank you. Ms. Day, any comment you wish to make? Opening statement.
Yes, sir, nothing.
Mr. Hawley, do you wish to call a witness?
Yes, Judge, I'd like to, at this time, I'd like to call Detective Gary Bernier with the Port St. Lucie Police Department.
Okay. Fellas, if y'all wouldn't mind having Officer Bernier come in. Mr. Brogoni, will be honorary bailiff, if you can do that.
Go ahead.
Thanks for bearing with us. Just have you raise your right hand, please. Do you swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Okay, step right up here to your left. Watch your step for me. Mr. Hawley, whenever you're ready.
Thank you. Please state your name, sir.
Gary Grenier.
And where are you employed?
G-R-E-N-I-E-R.
Where are you employed, sir?
Port St. Lucie Police Department.
And how long have you been employed with the Port St. Lucie Police Department?
Approximately 18 years.
And what is your specific job duty or description presently?
I'm assigned to the Special Investigations Division or Narcotics Division.
And were you working in that capacity on March the 6th of 2009?
Yes.
And on that day, you executed a search warrant on the residence of 713 Southwest Avon Street, Port St. Lucie, Florida. Is that correct?
Yes.
Okay. And you actually were the affiant who signed off on the application for the search warrant?
Yes.
And you alleged several things in there based upon information that you had received from a confidential informant, correct?
Yes.
In your affidavit, it's not mentioned, but it's presumed this gentleman, was he working off charges or was he working in lieu of charges?
Yes, he had been arrested prior to this.
And you don't mention that in your affidavit that he was working in lieu of charges, but would you believe that there be an additional problem or component to his truthfulness or veracity? Would it be less likely that he would tell the truth if he was working off charges or if he was a concerned source or a concerned citizen? Would you agree with me that it's a less likelihood if he's working off in lieu of charges as far as his truthfulness and veracity?
I'm not sure about that. I mean, that's why we try to corroborate what they tell us.
Okay. This particular confidential informant, we had taken your deposition a few months ago, correct?
Yes.
Okay. And at that point, I think you indicated you'd never utilized this individual before. Is that correct?
Yes.
And in fact, you never had utilized this individual after this event.
Correct.
And as far as the information you obtained from him, you had no independent corroboration of some of the things that were alleged in the search warrant. Is that correct?
Some of the things, correct.
Okay. And as far as some of the things that I'd like to delineate now are the fact that the CI stated that there was approximately 50 to 60 pounds of cannabis in the residence. That was not corroborated by you, and I'm talking about before you signed off on a search warrant.
Correct.
Okay. And the fact that the CI stated there was also oxys and roxys in the residence, that was not corroborated by you prior to execution of the search warrant.
Correct.
Okay. And the fact that there were scales, a scale to weigh narcotics, that was not corroborated by you prior to the execution of the search warrant.
Correct.
Okay. The fact that the CI receives weekly deliveries of 40 to 60 pounds, the last delivery being 48 pounds on Monday, February 16, 2008, that was not corroborated by you prior to the execution of the search warrant.
Correct.
Okay. What was corroborated by you was the fact that a male occupant by the name of Cobb and Debbie Cobb were residing at the residence, correct?
Yes.
Okay. Now, you also state in here, let me back up a little bit. On February the 17th, it's alleged in your application for the search warrant that the confidential informant was at the location and you were not present.
Yes, sir.
Okay. And during that day, he witnessed approximately the 48 pounds of marijuana.
I believe he stated 60.
60. Okay. And when, upon that day, actually 2 days later, a controlled delivery was taking place at Mr. Cobb's residence, correct?
I believe it was the next day.
The next day. Okay. And you would agree that there's a distinction between a controlled delivery and a controlled purchase. One is there's an exchange of marijuana for maybe a front type arrangement, and the other one may be a transaction involving a monetary exchange.
Correct.
And so that one involving a purchase involves cash or money.
Yes, sir.
And one involving delivery may involve some obligation in the future.
Yes.
Prior to you arriving at Mr. Cobb's house at 713 Southwest Avon Street on the 18th of February, you were monitoring your CI, correct?
Yes, sir.
Okay. And you were doing so through a video or an audio recording device.
Correct.
Prior to arrival at Mr. Cobb's house, I believe we've talked about this before, that he had to be redirected on 3 separate occasions to Mr. Cobb's home, that he had gotten lost.
I don't know. I don't recall how many times he was redirected, but at least one time he was redirected.
If you were to play the tape, which maybe saving the time of saying or playing the tape, is that you would there were at least two episodes of him being lost on the direction to that.
There could have been.
Okay. Now, when he had told you that he had been to the residence the day before, and then you were accompanying him the day thereafter, and he said that he had been there, and that he had been lost. Now he had been there being lost on several occasions. Did you not think that may affect his? Let me ask you this: did you not find that problematic?
No, sir. Actually, I took him there during the daylight hours. I drove him as a passenger, and he had no problem finding the house in the daylight hours.
But the day that that was the day prior to, correct? The day that he was there, you weren't there with him on the 17th, correct?
No, sir. I actually drove him there on the 18th.
Correct.
Earlier in the day when it was light out, and he had no problem finding the residence.
But he stated he was also there on the 17th, correct?
Yes, sir.
And then on the 18th, he had to be directed on at least 2 separate occasions to that location.
When he drove by himself after dark, yes.
Okay. But when he was there by himself and he observed the marijuana, you weren't there, he was able to drive himself there, correct?
I
on the
believe
16th?
So. I don't know if he was there by himself or with others.
But you didn't direct him there on that day?
On the 17th?
On the 16th. Excuse me, the 17th, the day that...
No, on the 17th I did not.
He was able to drive himself there on his own free will and volition?
Yes, I believe he did.
But the day after, you had to show him how to get there?
On the first occasion, he showed me how to get there, and then after dark, he had to be redirected on how to get there.
Okay. And when he arrived at the residence, he said that you stated on your affidavit that the CI was searched for contraband with negative results. He walked up to Cobb's garage. Did you see, where were you positioned at that point? Where was your surveillance?
I utilized another detective positioned on the street to observe him entering the residence.
He wasn't across the street, he was down the street, correct?
I believe you can ask him specifically where he was parked.
Okay. But you yourself did not see confidential informant walk into Cobbs' home, correct?
No, sir, I did not.
And you did not see the CI meet with Cobb, did you?
No, sir.
In fact, did you ever see Cobb that day?
I believe I did earlier in the day, standing in the driveway.
But never associated with this actual situation, correct?
Not during the transaction.
Okay. Now, when the CI says that he told your client that Cobb was in the process of bagging up cannabis when the CI entered, you were unable to corroborate any of that prior to the execution of the search warrant, correct?
Yes, sir.
And when the CI says that Cobb gave the CI a Ziploc baggie of cannabis and the CI left the residence, let me ask you this, do you have any independent corroboration that the CI received that from Cobb? Did you see it?
No, sir.
Did you hear it?
No, sir.
Was it on video?
No, sir.
Other than what the CI had told you, there's no other way to corroborate that allegation, correct? That Cobb gave the CI a Ziploc baggie of cannabis and the CI left the residence, other than what the CI said to you?
Yes, sir.
And then later the CI was followed to an undisclosed meeting place where the bag of cannabis was recovered.
Yes, sir.
Okay. Then ultimately, you did execute the search warrant on March the 6th of 2009 on the residence?
Yes, sir.
Okay. And you were accompanied by several members of the Special Investigations Unit?
Yes, sir.
Okay. Who were those other officers?
I don't have that list in front of me, sir, but I know that on that day the SWAT team executed the search warrant and then detectives came in afterward.
And you were also present for the execution of that search warrant, correct?
Yes, sir.
Okay. Because it was your warrant and your CI?
Yes.
Okay. And ultimately, upon the execution of the search warrant, as far as what the CI alleged, 40 to 60 pounds of marijuana were not found in the residence, were they?
No, sir.
And there were no oxys or no roxys found in the residence, were there?
No, sir.
And there were no scales in the residence, were there?
I don't believe so.
And I think I missed this issue, but I'm going to address it with you. Prior to the execution of the search warrant, you were unable to corroborate whether there were any guns in the house, correct?
Correct.
And after the execution of the search warrant, you did not find any guns in the house, correct?
Correct.
And you didn't find any scales in the house, correct?
I don't believe so.
Additionally, we had discussed this at depot that 40 to 60 pounds of marijuana are baggage in very large containers and or if not Ziploc bags, correct?
Yes, sir.
And upon the execution of the search warrant, you didn't find any large baggies or housing devices, did you? As far as to hold 40 to 60 pounds of marijuana?
No, sir.
And we discussed that 40 to 60 pounds of marijuana would make a significant mess if you were to be be measuring those out individually, the weights and things of that nature, correct?
Yes, it could.
And you didn't find anything on the floor of the garage or anything in the whereabouts to confirm that he was in the process or he just completed bagging 40 to 60 pounds of marijuana, did you?
No, sir.
Okay. What ultimately did you find inside the residence?
I believe we found cannabis and crack cocaine.
Okay. And this execution, the search warrant was actually executed several weeks after. It was the February 18th, and then the warrant was executed on March the 6th, 2009, correct?
Correct.
Okay. Was constant surveillance made on the home during that time frame?
No, sir.
Okay. So there was a gap. There was approximately 2 weeks or almost 3 weeks where no surveillance was done on the premises.
There may have been periodic, but nothing was noted.
Okay. And then the search warrant was executed.
Yes, sir.
Would you not agree with me if at best the information that the confidential informant had revealed to you was stale?
No, sir.
Okay.
Well, staleness is an issue, is it not, for the reviewing magistrate to determine whether information is stale, not after the warrant's been
I understand that.
signed. So I'm not sure that's pertinent.
Moving on. And as far as the execution, we talked about the execution of the warrant. Most of the information the CI gave to you was not revealed there, was not found. Or the objects that he had told you would be located in that home were not found there, correct?
Not to the quantity, no.
Okay. In fact, the only item, there's really no revelation here as far as cocaine. It's just that there's a marijuana, correct? your allegations don't reveal cocaine were to be found in the premises. Just marijuana is really the only thing that was corroborated, correct? Marijuana was found in the residence?
Yes.
Okay. And as far as, I want to get back to this point, the CI is the only one who gave you the information that Cobb handed the cannabis to him, correct?
Yes, sir.
Moment, Judge?
Yes, sir.
Thank you. Do you recall a conversation with the, do you recall the confidential informant stating on the tape, I just passed Cobb in a red Jeep? Do you recall anything of that nature?
No, sir.
Okay. Do you recall anything else as far as the tape was concerned? And we talked about the redirection upon several occasions. But you don't recall any of the prior exchanges that the confidential informant was huffing and things of that nature on the tape?
No, sir.
Okay. Judge, I don't think I have any further questions of Mr. Day.
Thank you. Ms. Day, do you have any questions?
Detective Grenier, you mentioned that one of the things you try to do when you're working with somebody that you haven't been able to verify their veracity, as you were not in this case, is that you try to corroborate things that they tell you. Is that right?
Yes, ma'am.
Okay, and one of the things, according to your search warrant application, that this confidential informant told you was that there was an individual at this residence and he gave you some descriptions of vehicles that were located at the home. Is that right?
Yes, ma'am.
Did you have a chance to do surveillance on that home to determine if what this confidential informant told you really existed at that residence?
Yes, I did.
Okay, and did what you personally observed doing your surveillance at the residence corroborate what that confidential informant had told you about that?
Yes.
Can you be specific and tell the court what that was?
He told me that normally there would be a maroon Jeep, a gold Lincoln, and a gold SUV located at the residence. And I did observe a four-door Lincoln at the house, also a maroon Jeep. I noticed to be in the driveway.
And you mentioned earlier, but did you also observe an individual in the driveway?
Yes, I did.
Okay. And did that individual match the description that the confidential informant had given to you prior?
Yes, ma'am.
Okay. Now, also the affidavit or the application for the search warrant makes reference to, in subsection F, that detectives conducted computer records checks of that residence. Now, why do you as detectives do these computer records checks to corroborate a confidential informant statement to you?
To verify the information that he said that a subject by the name of Cobb lived there. So I checked prior police reports to see if that was in fact correct.
Okay, and what were the results of those checks?
I did find at least one police report that identified Willie Cobb as being a resident.
Okay. So you were able to somewhat corroborate what this confidential informant was telling you based on your personal surveillance and also your checks of the residence pointed out by that confidential informant in determining that someone with the last name of Cobb did in fact live at that residence. Is that correct?
Correct.
Okay. Now, on February 18th, 2009, we're talking about this controlled delivery of cannabis that was from this residence. You mentioned that you conducted a search of the confidential informant. Is that correct?
Correct.
Did you search his person?
Yes.
Did you search his vehicle?
Yes, I did.
Okay. Was surveillance maintained on this confidential informant by yourself or one of the other Port St. Lucie detectives from when the search was conducted until this confidential informant went inside the home?
Objection, Judge. I don't think you can attest to what the other Port St. Lucie officers have observed. That's cause for this speculation. Mr. Wade can clearly know what another officer may or may not observe. That wasn't indicated in his report.
Okay, well, all right. Well, I assume Ms. Day, you're asking what he observed. So.
Well, I'm asking him because he's the assigned in the search warrant, and part of my argument is going to be the fellow officer rule applies in search warrants. And I'm also going to have that officer testify, the one that did personally observe it. I'm just testifying to what he was told to him because that goes along with why he was
all right. As long as that's being what it's offered for, I'll overrule the objection.
I guess I should rephrase that, though, to say, was the controlled situation set up in a fashion that some detective would have the vantage point of being able to observe the confidential informant going inside this home where Mr. Cobb or the target of this search warrant?
Yes, ma'am. I believe we used 3 undercover vehicles and approximately 6 detectives.
Okay, and you personally did not observe that. Is that accurate?
Correct.
Okay. Now, you are the affiant of this search warrant, but after this controlled situation took place, this controlled delivery of cannabis, did you have a chance to speak with any of the other detectives that did make these observations?
Yes, I did.
Okay. And were their observations incorporated into your application for the search warrant?
Yes, ma'am.
Okay. And specifically, was that Detective Kennedy?
Yes, it was.
Okay. Did you have a chance to search the defendant after he had gone into the home that was part of the search warrant?
You mean the
Yes,
You mean the CI?
I'm sorry, yes, I'm sorry, the CI, the confidential informant.
Yes.
Did you have a chance to search him? Okay.
Yes.
And again, you mentioned you searched his person and his vehicle prior. When you searched him after this, what did you find?
Oh, we followed the CI, or I specifically followed the CI back to a location. Immediately upon getting out of the car, he handed me a bag of marijuana, and then I searched him in the vehicle.
Okay. And you testified about your training experience as a law enforcement officer. Were you able to identify that substance as being marijuana based on your training experience?
Yes.
Did you field test that item on scene?
Yes, I did.
Okay. And again, that information was put in your application for search warrant, is that right?
Yes, ma'am.
Okay. And again, the confidential informant, did he stop at any other place? Did you lose any surveillance on him from the moment he left that home until he was searched again?
No, ma'am.
Okay. Now, once you completed your application for search warrant, did you take it to the Assistant State Attorney's Office or the State Attorney's Office to have an Assistant State Attorney review that?
Yes, I did.
Okay, and is that part of your normal procedures as a detective with Fort St. Lucie?
Yes, it is.
Okay, and after having that done, did you take it to a judge to sign that warrant?
Yes, I did.
Okay, and what judge was that?
I believe it was Judge Ikuchi.
Okay, and did Judge Ikuchi read that warrant?
Yes, he did.
And he did so in your presence?
Yes.
Okay. Now, you've had a chance today to look through, obviously you wrote it, but you've had a chance since then to review the application for search warrant. Is there anything in there, even looking back on it, that was false or that was a lie that you can see based on your knowledge at the time when you wrote this?
No.
There was no audio recordings of any conversations that the CI may have had with the target inside of the residence. Is that right?
Yes.
Can you tell the court why that happened?
The CI removed the equipment prior to entering the home.
Okay. Can you tell the court what steps you took to ensure that there was going to be an audio recording? Or what typically what your procedures are and how you set up that there is going to be an audio recording in this type of situation?
The CI is equipped with electronic monitoring device, so we can record and also listen to what's taking place.
Okay. And in this particular case, what happened?
The CI removed the equipment.
Okay. But regardless of that, you were able to determine, along with the Fort St. Lucie police, that when the confidential informant went inside that home, he had no marijuana. Is that right?
Yes.
And when he left that home, he had marijuana.
Correct.
Okay. Any other questions?
Mr. O'Leary, redirect.
Yes, sir. Let me back up. As far as surveillance on the home, you identified the home. It's 713 Southwest Ames, correct?
Yes, sir.
Okay. But you didn't actually conduct any surveillance that revealed or corroborated any indicia of any drug sales or narcotics activity at that residence, did you?
No, sir.
And your CI just took it upon himself to remove the audio and video monitoring device?
Yes.
Okay. Why did you omit that from your application for search warrant?
I couldn't tell you.
Would you not agree with me that that's a very important fact of this case? In fact, just recently discovered to counsel. You would not agree with me that the fact that the CI you'd never used before and never used again had taken off his monitoring and listening device was not an important fact for the magistrate to consider at the time that they executed the search warrant?
I felt that we had him under surveillance and observed him enter and leave the home.
But not very adequate surveillance, correct? The fact that there's no way to corroborate, when that was removed, there was no way to corroborate anything he said.
Other than the detective's observations of him entering the garage.
But the detective, you agree with me that you never saw a hand-to-hand transaction or any monetary value or anything exchanged?
Correct.
And this transaction was not a sale. There was no pre-recorded money. There was no currency. There was nothing ever put in evidence with respect to that.
Correct.
It was actually what's called a delivery, meaning that somebody may front marijuana or give it to someone for an exchange for maybe money or some type of obligation down the road.
Correct.
But in this case, you don't clearly there's no way to discern whether it was a delivery or whether it was a sale or whatever transpired because you actually sufficiently didn't keep a proper monitor on this confidential informant.
He was supervised and he was observed entering the home.
But that was it. So all we've got really is a confidential informant entering a home, saying he met someone, and saying he received drugs from him, but we have no way of corroborating any of that, correct?
Well, he had no drugs on him before he went in the home, and he had drugs on him when he exited the home.
And you don't even know if he met with Cobb, correct?
Other than his statement.
Other than the confidential informant statement who took his listening and monitoring device off before he...
I get the idea. I got it.
Thank you. No further questions.
Any other questions?
You didn't provide the confidential informant with any funds to make a purchase, is that right?
Correct.
Why is that?
Because it was just going to be a delivery or a front.
Okay. And that was the plan the entire time, was for him to go into the house and see if he could get any drugs. Is that correct?
Correct.
Okay. All right, no other questions?
Mr. Holy, anything further?
Nothing further, Judge. Thank you.
Okay, thank you, officer. You can step down. Watch your step. Let me give you all a little bit of a heads up time-wise. About 12:40, I got to leave to go to the doctor.
Yeah, Judge.
If you're not done by then,